Assalamualaikum and good evening to lecturers and friends. My name is Erna Elena Binti Johar with a metric number of 64232, and I would like to introduce our business background that owned by 12%. So basically our business name is It's D Cookies Limited, based on Companies Act 2016 that includes in section 11(1), a company limited by share shall either be a private company or a public company. So the idea of making a cookies company were agreed from all members. Each of us has the specialty on cookies interest and also our own secret recipes. It's D Cookies is located at number 647 Desa Ilmu at Kota Semerahan, and our objective is to be the best sellers among others in Malaysia that allows customers to choose their own design, color of packaging, and also our mission is to be the first one to distribute an affordable yet a healthy cookies for everyone. Well, this plan is to help the customer to taste the uniqueness of our variety cookies. We are targeting a customer who concerned about their healthy eating lifestyle, which will provide a good energy for body intake and prevent fat. Everyone loves it, right? And it contains good nutrition. Our company initial expenses will be financed by founding members of 12, which each contributing 10,000 each, amount which in a total capital is 120,000. So in the first 12 months, we do not expect to make any significant gains because we are just make a brand name and study the market reaction first. Within a few years, this business will grow in terms of profit and will also further expand throughout Malaysia. That's all from me.
One of the distinctions between a company and a partnership is a company is an independent legal entity owned by the shareholders, in which the shareholders decides on how the company is run and who manage it, while partnership is an agreement between two or more persons who comes together to carry out a business and share the profit and loss mutually. In terms of governing act, companies is regulated and controlled by the Company Act 2016 and are required to register under the act. Partnership firm is regulated by the Partnership Act 1961, but the registration of the partnership firm is not compulsory under the Act, as it is based on the partnership deed. Furthermore, a share of a company can be freely transferable to anyone, but in partnership, the partner are unable to transfer his share without the consent of all other partners. The person can only be introduced as a partner with the consent of all existing members.
A company that is agreed to be formed is private limited company by shares. A private limited company is known as Sendirian Berhad in Malay. This is company limited by shares of its shareholders. This type of company has some defining characteristics. A company that is limited by share of its shareholders is where the liability of the shareholders is limited to the amount of shares they are holding. The shareholders' personal assets and properties in other business cannot be attached to recover any debts accrued by the company. The debt or living of shareholders does not mean that the company is wound up. Thank you.
Now, let's talk about company name and its restrictions. First of all, the company name shall end with Berhad for public company, Sendirian Berhad for private company, and also Sendirian for unlimited company. Next, a name can be only be taken if it's desirable and acceptable, and it's also not identical to other company names, and it's also not a name that the minister has told the registrar to not accept for registration. Thank you.
Hi, I'm Yuni Suslin Tan. So I'm going to share with you the steps which must be taken in order for a company to be formed. First, hold a meeting of all partners of the partnership firm. because the liability of a company members is limitless. So, if a firm wish to file as a limited company, the majority consent is required. There should not be less than 3/4 of the partners in person. Second, assent from secure creditors of the firm. Additional written assent or no objection certificate is to be acquired from secure creditors of the firm. Third, getting the name approval in Reserved Unique Name Facility or RUN for the proposed company. Fourth, distributing the advertisement in 2 newspapers, which is the English Daily and Vernacular. The purpose of doing this is to look for any complaints. The next step is file an affidavit for its dissolution as partnership firm consequent to its conversion into private limited company. And the last step is documenting of all important parts with the ROC, Register of Company, for the endorsement of transformation and the enrollment of the firm into the private limited.
Hi, my name is Vivian Ivy and Richard McLeaf, and my matrix number is 64390. I'm going to explain about the company constitution. A company constitution Malaysia referred to as a previous article of memorandum associated the Organisation in Companies Act 2016. A company constitution is not relevant in all consumptions, especially in its cookies limited, as a company limited by share can choose whether or not to have a constitution. According to Section 31(1) Companies Act 2016, the company limited by guarantee may or not be has a constitution. Our company has met an option for a company objective. So there are certain constitution that its cookies limited has choose, which are included share attrition of rights, call of share line, transfer of share, transmission of share, vote of members director, power of duties of director, proceeding in director, validation of acts of directors, circular resolution, managing directors, minutes and registers, associated director, secretary, sales reserve, dividend, specialization of profit, financial statement, audit clause, immunity, restriction, effect of listing requirements, the Act, censure of these stories, acts and rules. Our company is not listed in Bursa Malaysia as the cookie is just started and have not earned the standard of Bursa Malaysia in terms of profit.
Capacity. First is contractual capacity. Contractual capacity is a company's legal ability to enter into agreements with other parties and is responsible for the terms of a contract. Its cookies has unlimited capacity. This means that the company should to capable of carrying out all the function on the body corporate and having full capacity to carry on or undertake any business or activities, include to sue and be sued, to acquire, on, hold, develop or dispose of any property, perform any act it may perform, or to make a transaction. The company also have the full rights, power and privilege for this purpose.
So I'm going to talk about the rights of the company's shareholders and members. According to the Companies Act 2016, the shareholders and members of its These Cookies company are able to enjoy several rights and their own authorities in the company's management. Their rights can be categorized into 3 groups. First is statutory rights. Statutory rights refers to the rights that conferred for the shareholders and members by the Company Acts. These rights cannot be taken away by the Memorandum of Association. There are few statutory rights that are given to the shareholders and members, which are the rights to receive notice of meeting, attend, participate in the discussion of a meeting, the right to receive copies of the annual account of the company, the right to vote on a show of hands in any resolution of company, and the rights to an equal share in dividend. The next is documentary rights. In addition to the statutory rights, there are certain rights that can be conferred to the shareholders and members by the documents like the memorandum and the articles of association. Legal rights is also one of the rights that shareholders and members are able to enjoy. Legal rights refers to the rights that are given to the shareholders and members by the general.
The board of directors are mainly responsible for all management in the business in company. The board of directors is the cookies company have power to entrust power to each director as deemed fit.
For the liabilities of the company, East the Cookies Company is a private limited company. A company limited by shares can have no more than 50 shareholders. If a private limited company is in financial trouble and has to close down, shareholders will not risk losing their personal assets. Liabilities that East the Cookies Company apply as laid out by the Companies Act 2016 is responsibility to function within their powers as laid out in the company's constitution, improve the company's success, apply independence judgment, apply realistic diligence, skill and care. East the Cookies Company must also reject benefit from any third party and real interest in a planned arrangement or transaction.
Next, I will talk about effects of its incorporation. What is incorporation? According to Hayes 2019 states that incorporation is the legal process used to form a corporate entity or company. The process involves writing up a document known as the Articles of Incorporation and recording the shareholder of the company. There are 5 incorporation advantages for a business and for the owners. First, protects the owner's asset towards the company's liabilities. Second, enable an easy transfer of ownership to another party. Third, achieve a lower tax rate than the personal income. Fourth, receive more lenient tax restriction on loss carry-forwards. 5. Enable to raise the capital from the sale of stock. Effects of its incorporation. Based on Section 18, subsection 1, on the date of incorporation stated in the notice of registration issued under Section 15, it shall be accompanied with the name and the number of registration as specified in the principal kept by the registrar for this purpose. For instance, it the cookie, which is partnership, and the cookie Ltd PLC, and put together with the registration number, which is DC34567.
Hello everyone, my name is Hisham, and very good evening to our lecturer and my fellow classmates. Today I'll be talking about our company, The Cookies, and specifically my part, the extent which the shareholder can be liable of the debt of the company. The liability of those debts will pass to the shareholder personally. Then he can be reassured by the fact that as a shareholder he has a limited liability for the debt of the company. That means he is only responsible for the company debt up to the risk he took. In more simple words, the only money he will be risking in case the company fail is the money he put in, which is his part. Thank you.